Site 42 U.S. Standard Code Section 11,041, the Public Health and Welfare Emergency Planning and Community Right to Know General Provisions Section 11,041, Relationships to Other Law. In general, nothing in the chapter shall permit state or local law to the except the provided in subsection, and B, the section otherwise affected the state, local law, and authority of any state or local government to adopt, enforce state or local law, or 3, affect or modify in any way obligations, liabilities of any person under the federal law. B, effective MSDS's requirements of state local law enacted on August 1st, 1985, which requires submission of material safety data sheets from the facility owner. Operators shall require the data sheets be identical in content, format, and data sheet shall, under the Section A, Section 11,021 of this title, additional in a state, local, locality, it may require the submission of information which is supplemental to the information required on the data sheet, including information on the location, quantity of the hazard, chemical presence at the facility through additional sheets attached to the data sheet or such means of the state locality considered appropriate. Sources: Pub 99 through 499, Title 3, Section 321, October 17, 1986, 100 Stat 1747. Site 42 U.S. Standard Code Section 11,042, the Public Health and Welfare Emergency Planning Community Right to Know General Provisions 11,042, Trade Secrets, other authority to withhold information, general authority with regard to chemical hazard and extremely hazardous substances and toxicity of any person required in Section 11,003, D2, 11,003, D3, 11,021, 11,022, 11,023 of this title, submit information to any other person may withhold in such submittal the specific chemical identification, including the chemical name of the specific identification as defined in the regulations prescribed from the administration under subsection of this section. If the person complies with the paragraph 2, any person withholding a specific chemical identity shall in place submittal with a chemical identity normally be included in the generic class or category of the hazardous chemical, extremely hazardous substance, or toxic chemical, as in the case may be. 2, requirements of person entitled without information under the paragraph. 1, if such a person 1 claims such information of a trade secret on the basis of information enumerated in subsection B of this subsection. 2, includes submit it'll referred to in paragraph. Explanation: reason for information is claimed to be a trade secret based on factors enumerated by subsection B in the section, including a specific description of why such factors apply. Description of 3, of submits the administration of a copy of submittal information withheld and submittal. B, in submitting the administration and the information required, subparagraph A 3, a person withholding information under the subsection may designate in writing in some manner as the administration prescribes regulation with the information which such person believes entitled to be withheld under the paragraph 1 and 2. The submittal such designated information separated from the other information submitted under the subsection. 3, limitation of the authority of subsection within hold information should apply to information administrator has determined in accordance with subsection C, and the section is not a trade secret. B, the trade secret factor. No person required to provide information under the chapter claim the information entitled the protection of a trade secret under subsection A of the section unless such a person chose each of the following. 1, such a person is disclosing information to any other person other than a member of the local emergency planning committee, any officer, employee of the United States and state of local government, employee of such person, or a person who is bound in confidential agreement, and such a person has taken a responsibility measure to protect confidential such information, intends to continue to make such measures, and the information is not required to disclose otherwise available for the public under any other federal state law. Disclosure of the information is likely to cause substantial harm to competitive position of such person. The chemical identity is not readily discovered through the reverse engineering. C, the trade secret regulations as soon as particularly practicable after October 17, 1987, the administration shall prescribe regulations to implement the section within respect to subsection B4, the section regulation shall be equivalent to comparable provisions, occupational safety, health administration, communication standards, 29 CFR 1910 to 1200 series, and revision and standard prescribed by the Secretary of Labor in accordance to the final ruling of the courts of the United States of United Steelworkers of America, the AFL-CIO of CLSC versus Thorne and Archer. D. A petition for review. 1. In general, any petition with the administration for the disclosure of specific chemical identification of hazardous chemical and an extremely hazardous chemical substance of toxic chemical which is claimed in trade secret under the section of the administration may be, in the absence of petition and paragraph initiated, determination to be carried out in accordance with this subsection with their information withheld or constitutes a trade secret. Initial review within 30 days after the date of receipt of a petition under the paragraph 1 upon administration initiative shall review the explanation filled in with the trade secret claimant under the subsection A2 of this section, determines whether the explanation represents the assertions within the truth sufficient as to support finding specific chemical identity of the trade secret. 3. Finding sufficient assertions that A, if an administration determines pursuant in paragraph that the explanation sufficient assertion in the support of finding specific chemical identity is trade secret, the administrator shall notify the trade secret claimant of the 30 days of supplemental explanation and detailed information to support assertions. B. Then the administration determines after receipt of any supplemental supporting detailed information under subparagraph A, the assertion of the explanation of are true and that the specific chemical identification of trade secret, administrators shall notify the petitioner and petitioner may seek a judicial review of determination. C. The administrator determines after the receipt of any supplemental supporting detailed information under subparagraph A, the assertions of the explanation are not true and that the specific chemical identity is not traded in secret. The administrator shall notify the trade secret claimant of the administrator intends to release specific chemical identity. Scroll. The trade secret calamity has 30 days in which they make an appeal for administration determination of subparagraph administrator. The administrator does not reserve the determination of subparagraph in such appeal by the trade secret claimant that the trade secret claimant expectation 1 may seek the judicial review of determination. 4. Finding insufficient assertions and administration determines in pursuant to paragraph 2 the finding that the explanation presents the insufficient assertion to support the finding of the specific data chemical identity of trade secret. The administrator shall notify the trade secret claimant that he has 30 days to appeal for the determination of the administration or has upon showing the good cause of amending the original explanation by providing supplemental assertions to support the trade secret claim. The administration does not reverse determination under subparagraph appeal the examination of supplementary assertion under the subparagraph A. The administration shall notify the trade secret claimant. Trade secret claim may be judicial review of the determination. C. The administration reverses determination under subparagraph after an appeal of explanation of the supplementary assertions under the subparagraph A. The procedures under paragraph 3 in subsection apply E, the exemption of the information provided to the health professionals. Nothing in section of regulations and adopted by the pursuant of this subsection authorizes a person to withhold the information within it required to provide a health professional, doctor, and nurse in accordance with subsection 1104.3 of this title. Provision provided information and administrative availability to public information submitted in administrative subsection A2, the section subsection D3, the subsection except for the subsection chemical identity shall be available for the public except for showing satisfactory administration of any person the information or a particular part of thereof to which would which the administrator has assessed under section if the public would divulge information entitled to the protection under the section 1905 of Title 18, if such information shall be part and considered confidential in accordance with the purpose of the section, except for information may be disclosed, and other officers, employees as authorized representing the United States concerned with carrying out these chapters. And G, the information provided in the states upon the request of the states acting as the governor of the state and administrator shall provide a state and information obtained under the subsection A2 of the section of subsection D3 of this section. H, the information of the adversary effects. In any case of the identity of a hazardous chemical or extremely hazardous substance is claimed for a trade secret, governor, state emergency response commission established under this section 11,001 of the title shall identify adverse health effects associated with a hazardous chemical, extremely hazardous substance, shall assure that such information provided any person requesting information about such hazardous chemical, extremely hazardous substance, and to any case which identity of the chemical is claimed as a secret trade secret administrator shall identify the adverse health and environmental effects associated with the toxic chemical and shall assure that information including the computer data required in subsection 11,023 of this title is provided by any person or information about the subtoxic chemical. And one, the information provided in Congress, notwithstanding a limitation of exploited to contained in section on the other provisions law, all information reported to any other appointed administrator or representative administrator under the chapter shall be available to the administrator and shall be available to a duly authorized Congress upon the written request. Pub 99 through 4099, Title 3, Section 322, October 17, 1986, 102, Stat 1747. So original probably should be claimant and two exclamation probably limitation. Expedite Title 42, the Public Health and Welfare, Chapter 116, Emergency Planning, Community Right to Know, Subchapter 3, General Provisions, Section 11,043, Provisions of Information and Health Provision, Professionals, Doctors, and Nurses, Diagnosis and Treatment of Health Professionals, Owners, and Operators of Facilities, and subject to the requirements of Section 11,021, 11,022, 11,023. The title shall provide specific chemical identity if known and hazardous chemical, extremely hazardous substances, toxic chemical to any health professional who requests such information in writing. If the health professional provides a written statement of needed under the subsection, a written confidentiality agreement under subsection D of this section, a written statement of the needed shall be the statement of the health professional has responsible basis and suspect that one information is needed for purpose of diagnosis, treatment of individual or individuals being diagnosed or treated have been exposed by the chemical concern. 3. The knowledge of the specific identity of such chemical will exist of diagnosis of treatment. Following as such a written request, the owner and operator to whom such a request is shall promptly provide a requested information health professional authority within the specific chemical identified of the chemical under the section 11,042 of this title, of which information trade secrets shall not apply to the information required to the provided in the subsection subject to the provisions of subsection D of this section. B, the medical emergency owner operator of the facility which is in the subject requirements of section 11,021, 11,022, 11,023 of this title shall provide a copy of material safety data sheets as in an inventory form, a toxic chemical release form, including specific chemical identity if known, and hazardous chemical, extremely hazardous substances, or a toxic chemical to any treating facility physician or nurses who request such information, or if physician or nurse determines that 1. The medical emergency exists, 2. The specific chemical identity of the chemical concerned and necessary will assist the emergency first aided diagnosis of the treatment, and 3. Individuals being diagnosed diagnosed and treated have been exposed to chemical concerns. Immediately following such a request, the owner operator to whom such request is made shall be provided request information to the physician and nurse's authority to withhold the specific chemical identity of chemical for a material safety data sheet and inventory of toxic chemical released from under section 11,042 of this title. Such information is a trade secret, shall not apply to the information required to provide it to a treating physician nursing under the subsection. Not written confidentially agreement of statement of need shall be required as preconditions of such disclosure, but the owner operator disclosing such information may require a written confidentiality agreement in accordance with subsection D in the section A and a statement setting the items listed in paragraphs 1 through 3 as soon as the circumstances permitted. See the preventive measures of local health provisions. Provisions of information, an owner-operated facility subject to requirements section 11,021, 11,022, 11,023. The title shall provide the specific chemical identity known as a hazardous chemical and extremely hazardous substance and toxic chemical to any health professional such as a physician, toxicologist, epidemiologist who is local government employee or a person under contract with the local government who requests that such information are written and provide written statements needed in paragraph written confidential agreement under subsection of this section. Following such a written request, the owner operator to the such request is made and promptly provided requested information local health professional authority to withhold specific chemical identity of the chemical under subsection 11,042 title, and such information is a trade secret shall not apply to information required to provide under the subsection subject provision in subsection D of this section of 2. The written statement is needed. The written statement is needed. Written statement of need shall be made. Shall be a statement that describes responsible detail one or more of the following health needs of the information. 2. The access exposure of the person living in the local community, the hazard of the chemical concern. 2. The conduct of sampling determining exposure level to various population groups. To see the conduct of periodic medical surveillance exposed to the population groups. 2. Provide medical treatment to exposed individual population groups. 3. The conduct studies and determine the health effects of exposures. F. The conduct studies to aid the identification of a chemical that reasonably be anticipated to cause an observed health effect. D. The confidentiality agreement. Any person obtaining information under the subsection A or C of the section in accordance with subsection A and C agreement, that he will not use information for any purposes other than the health needs asserted for the state or needed except it as may otherwise authorized by the terms of the agreement, otherwise in person. Providing such information, nothing is subsection precluded, and is the parties' confidential agreement in pursuing the remedies to the extent of permitted law. The regulations as soon as practicable after October 17, 1986, administrative public regulations describing criteria, parameters, and statement of needed under subsection explanatory 1A and C and of this subsection confidential agreement subsection D of this section. Published L through 99 through 499 Title 2 or Title 3 Section 323 October 17, 1986 100 Stat 1750. Expedited 1 is the original problem should be subsections, and Title 42, the Public Health and Welfare to Emergency Planning Community Right to Know, Chapters 116, Subchapter 3, General Provisions 11,044, Public Availability Plans, Data Sheets, Forms, Follow-up Notices, Availability to Public, the Emergency Response Plan, Material Safety Data Sheets listed described as 11,021, entitled Inventory from Toxic Chemical Reform or Chemical Release Form. Follow-up emergency notice shall be made available for the general public consistent with subsection 11,000 or section 11,042. Locations, designation, administration, governor, state emergency response commission, local emergency planning committee, appropriate upon request, owner and operator of facility subject to the requirements of 11,002 of this title of the state emergency response commission. The appropriate local emergency planning committee would state shall withhold and disclose all under the location of any specific chemical required by section 11,022. The title be contained in addition inventory of Tier 2 information. B. Notice of public availability. The local emergency planning committee annually publishes notice in local newspapers, emergency response plan, and material safety data sheets. The inventory forms have been submitted under section, and the notice shall state the follow-up. Emergency notice subsection may be issued with sub-notice and annuance of membership of the public who wish to review, and any such plan sheet form and follow-up notice may be due to the location designated under subsection A of this section. Source pubs 99 through 499, Title 3, Section 324, October 17, 1986, 100 Stat 175-2. Title 42, the Public Health and Welfare, Chapter 116, Emergency Planning Committee, Right to Know. Subchapter 3, General Provisions, Section 11045, Enforcement, Civil Penalties, Emergency Planning. The administrator may have ordered the facility owner-operator, except for the owner-operator facility designated under the Section 11,002 B2 and of this title, comply with the subsection 11,002C of this title, Section 11,003 D of this title. United States District Court of the district in which the facility is located shall have jurisdiction to enforce the order, and any person who shall have jurisdiction to enforce the order of any person who violates the law, fails to obey such a law, shall be liable to the United States civil penalty not more than $25,000 for each day in which such a violation occurs. Such failure to comply continues. Civil administration civil penalties for emergency notification. Class 1 administrative penalties. The civil penalty is not more than $25,000 per violation. Assess administration case of violation of requirements of Section 11,004 of this Title B. No civil penalty may be assessed under the subsection unless the person accused of violation is given notice and opportunity from hearing, and with respect to violation and determination of amount of penalty as sourced assessed pursuant to the subsection. Administration shall take into account of the nature, circumstance, extent, and gravity of the violations in the respect of the violator, ability to pay, any prior history of violations, degree, culpability, accountability, benefit of savings, if any, resulting from the violation of such matters, justice and require Class 2 administrative penalty. A civil penalty of not more than $25,000 per each day during the violation continues, assessed by the administrator in the case of violation requirements, subsection 11,004 title. In the case of subsequent violation of the amount of penalty may be not more than $75,000 for each day during the violation continues. The civil penalty under the subsection shall be assessed and collected in any manner subject to the same provision of civil penalties assessed by collected number under the 2615 of Title 15. If any proceeding of the assessment of civil penalty under the section, administration may issue subpoenas for attendance and testimonies of witness and the production of the relevant papers and documents of promulgated rules and discovery procedures. Judicial assessment. The administrator may bring action in the United States District expedited one, court of the examination one, court of the appropriate district to the assess of collected penalty not more than $25,000 per day each of the day with the violation continues. In the case of the violation requirements of subsection 11,004 of this title, in the case of second subsequential violation, the amount of such penalty may occur up no more than $75,000 each day during which the violation continues. Crime and penalties. Any person knowing and willfully fails to provide notice in accordance with subsection 11,004 of this title shall, upon conviction, fine no more than $25,000, imprisonment for no more than 2 years, both or in the case of second or subsequent convictions shall be fined not more than $50,000, imprisoned for not more than 5 years or both. Civil administration penalties, reporting requirements, and any person or other than government entity who violates a requirement subsection 11,022, 11,023 of the title shall be liability under the state law of civil penalty in an amount of not more than exceeding $25,000 each violation. Any person other than the government entity violates the requirement of the section 11,022 and 11,043 of this title, and any required under section 11,042 2, and the title shall be in title, and any person who fails to furnish an administration of information required from 11,042A2, and the title shall be liable for the United States civil penalty in an amount to exceed $10,000 for each such violation. Each day violation described in paragraph 1 and 2 continues shall purpose the subsection consistent constitute a separate violation. The administration may assess the civil penalty for which a person or liable subsection administration or bring an additional action accession collection penalty to the United States District Court of the district in which a person from whom the penalty is sought to reside, in which the person principal place of business is located. Civil and administrative criminal penalties in respect to the trade secrets. Civil administrative penalty for frivolous claims if the administrator determines A1 that under Section 11,042 of this title that in explanation submitted to the trade secret claim and a representation or assertion to support the finding of a specific chemical identity of the trade secret. 2. The after receiving supplemental supporting detailed information of the Section 11,042 D3A of this title of the specific chemical identity of the trade secret. The trade secret claim is frivolous. The trade secret claim is liable of the penalty $25,000 per claim. Administrator may assess the penalty of administrative order per bringing action in appropriate district court of the administrator to assess the collective penalty to the criminal penalty and for disclosure of trade secret information. Any person knowing and willfully divulges and discloses information entitled in protection under Section 11,042 of this title conviction shall be in the fine or not more than $20,000 more or in $20,000 and more than $20,000 or imprisonment not to exceed 1 year or both. A special enforcement provision Section 11,043 whenever a facility owner or operator required to provide information under 11,043 the title of the health provision and requested that such information fails to refuse to have provided information in accordance with such section, such health and professional may bring an action appropriate in the United States District to require facility owner and operator to provide information. Such court as shall have jurisdiction and issue orders and take such other action and be as necessary to enforce as requirements of subsection 11,043 of this title. The procedure administrative penalties. Any person against the civil penalty assessed under this section of the obtain or review their appropriate district court of the United States following a notice of appeal such as the court within 30 days after the date of such order may be simultaneously sending a copy of such a notice in certified mail. An administrator shall promptly file in such court of certified copy of record upon violation was found or such a penalty imposed. If any person fails to pay an assessment of civil penalty after it became final and unappealable order, after the appropriate court has entered a final judgment in favor of the United States, the administrator may request the Attorney General of the United States to institute a civil action appropriate district or of the United States civil action United States to collect the collected penalty. Such court shall have jurisdiction to the hear and decide any such action in a hearing. As such action, the court shall have authority to review the violation assessment to the civil penalty recorded. The administrator may issue a subpoena in attendance to the testimony of the witnesses, production of relevant papers, procedure documents, connection of the hearings under a section in case in contumacy, refusal to obey, subpoena issued and pursuant to paragraph severed upon the person district court of the United States for any district in which the person is found, resides, and transacts business, and upon application of the United States after notices to such a person shall have jurisdiction to issue requiring such person to appear and give a testimony before administrative law judge and appear procedures, documents, and administrative law judge or both. Failure to obey such an order, the court may be punished by such a court as in contempt thereof. Published 99 from 4999 or 99 of 499, Title 3, Section 325, October 17, 1980, 1000 Stat 175. Examination 1 of this original probably should be capitalized. Title 42, the Public Health and Welfare Emergency Planning Community Right to Know General Provisions 11,046. Civil action authorized to bring civil action, civil suits except for provided subsection of the subsection personnel commands a civil action on his own behalf against the following: an owner operator of a facility for failure to do anything of the following: 1. Submit a follow-up emergency notice under the section 11,004 of this title. Submit a material safety data sheet or listed under subsection 11,021 of this title. 3. Submit an inventory for the under section 11,022 the title under the Interior 1 information described in 11,022 D1 of this title, unless the requirement does not apply by the reason of the second sentence of section 11,022 A2 of this title. And 4. Complete the submitted chemical release under the section 11,023 of this title. Administrate the failure to do any of the following: publish inventory forms under the section 11,002 G of this title. Is respond to the petition to add and delete chemical under section of 11,023 A and E1 of this title, and title within 100 days after the receipt of the petition. Publish a toxic chemical release from under 11,023 explanation 1 of this title. Establish the computer database in coordination of section 11,023J of this title. Promulgate trade secret regulations sections 11,042 of this title under decisions, responses, petitions under section 11,042 of this title within 9 months after the recipient receipt of petition. See the administration of the state governor or state administrative response commission failure to provide a mechanism for public availability of information in accordance to subsection 11,044 of this title. The state governor or state emergency response commission failure to respond to the request of Terrier 2 information under section 11,022 E and 3 of this title within 120 days after the day of receipt of request. The state or local suit any state of local government make compliance with a civil action against the owner and operator of facility in the failure to do any of the following: and provide notification of emergency response commissions in the state of under section 11,002 entitled submitted material safety data sheet and listed and under section 11,021 of this title, making availability information requested under section 11,021, and 4. A complete and submitted inventory form of under section 11,022A of this title containing Terrier 2 information, unless the requirement does not apply to by any means of second sentence of section 11,022A2 of this title. B. Any state-manned emergency response commission of the local emergency planning committee may commence a civil action against an owner of operator facility to failure to provide information under section 11,003 D of this title for the failure to submit Terrier 2 information under the section 11,022 E and M1 of this title. Any state may commence a civil action against the administrator for failure to provide information to the state under the section 11,042 G of the title. B. The venue of 1. Any action in subsection A of the section against the owner and operator facility shall be brought in district court in the district in which is alleged violation occurred to. An action under the subsection A of the section against the administration may be brought into the understated United States District Court for District Columbia. C. Relief. The district court shall have jurisdiction. An action brought up to subsection A, the section against an owner or operator facility to enforce requirements concerned to impose any civil penalty provided in violation to the requirement of the district shall have jurisdiction. Actions brought under the section against the administrator to order the administrator to perform active duty in concern. D. Notice: no action commenced under the subsection A1A of this subsection of the section prior to 60 days after the plaintiff had given the notice to alleged violation of the administrative of the state in which the alleged violation occurred. The legislative violator, in order that the paragraph shall be given in such a manner that the administrator shall be prescribed in regulation. No action shall be commenced under the subsection of A1 through B, A1B, and A1C, or the section prior to 60 days after the date of which the plaintiff gives notice to the administrative state governor or state emergency response commission, as in case may be that the plaintiff comments action. Notice that this paragraph shall be given in such a manner the administrator shall prescribe by regulation. And E. Limitation: no action may be commenced under subsection A of this section against the operator of facility. Administrator have commenced diligently pursuing the administrative order civil action to enforce the requirements concerned to impose the civil penalty under the act within respective violation of the requirements. Cost: the court of issue final order and any action brought by pursuant of the section may award costs of litigation, including the responsible attorney, expertise, witness, prevailing and substantial prevailing party, whatever the court determines the restraint order of the preliminary injunction is surface and sought the request of filling out bond equivalent secretary in accordance with the federal rules of civil procedures. Other rules, nothing in the section shall restrict and expand in a right in which a person or class of person may have under a federal state of command, a state of common law to enforce of any of the following and to seek any of the relief, including relief against the administration of state agencies, intervention by the United States of any action under the section of the United States and the state, or both, if not party, of the intervene as a matter of right. But two, by any person, any action under this section, any person that intervened as a matter of right, in which the person is directed interest in which is may be adversely affected in action and disposition of the action, and may practical matter impair, impede, and person's ability to protect interest, unless the administrative states that shows the person interest is adequately represented the existing parties in action. Source Public 99 through 49, Title 3, Section 326, October 17, 1986, 10 Stat 1755. Reference and text. The Act is referred to subsequently E. The Public 99 through 499, October 17, 1986, 100 Stat 16113. Amended is known as the Superfunded Amendments of Reauthorization Act of 1986. A complete classification of this act of the code is see short of the title of 1986 amendments note set for under the section 9601, the title and tables. The federal rules and civil procedures referred to as subsection F in the set out for appendix in the title of 28 Judiciary and Judicial Procedures. Explanation 1 of this set of originals probably should proceed by section. Title 42, Public Health and Welfare, Chapter 1116, Emergency Planning Committee, Right to Know, Subchapter General Provisions 11,046, Exemption, except for provided in Section 11,004 of this title. This chapter does not apply to transportation, including storage, incident of such transportation, substance, and chemical, is subject to requirements of chapter, including transportation, distribution, and natural gases. Sources published 9949, Title 3, Section 327, October 17, 1986, 100 Stat 1757. Title 42, the Public Health and Welfare, Chapter 1116, Emergency Planning and Committee, Right to Know, General Provisions 11,048, Regulations. Statute, the administrator may prescribe such regulations as may be necessary to carry out the chapter. Published 9949, Title 3, Section 328, October 17, 1986, 100 Stat and 1757. Title 42, the Public Health and Welfare Emergency Planning Committee, Right to Know, General Provisions 11,049, Definitions. The purpose of this chapter, the administrator. 1. The administrator. 2. Environmental. The term environmental includes water, air, land, and interrelationship with existing among between water, air, and land, air, all living things. 3. Extremely hazardous substances. The term extremely hazardous substances means substances list is described by 11,002 A2 and of this title. For the faculty means of all buildings, equipment, structures, and other stationary items in which located in a single site of contiguous agents. Adjacent sites which are owned and operated by the same person or any other person in control is and controlled by under common control with such person for purpose of section 11,004. The title of this includes the term motor vehicles and rolling stock aircraft. 5. The hazardous chemical. The hazardous chemical has means of giving such term section 11,021 of this title. 6. The material safety data sheet. The material safety data sheet means the sheet required to develop under the section 19.12000. G. The Title 29 of the Code of Federal Regulations. This section may be amended from the title time. A person means individual trust firm, joint stock company, corporation, including a government, corporation, partnership, association, state, municipal, Commission for Tactical Political Subdivision of the State, interstate body, and release. The term release means the slipping, leaking, and pumping, and pouring, emitting, emptying, discharging, injecting, escaping, leaching, dumping, disposing of the environment, including the abundant discarding of barrels, containers, and other closed receptacles of hazardous chemicals, extremely hazardous substances, or toxic chemicals. 9. The term state means the state of the United States, District of Columbia, Commonwealth of Puerto Rico, Guam, American Samoa, and the United States Virgin Islands and Northern Mariana Islands and other territories. Possession other than the United States has jurisdiction. 10. The toxic chemical. Toxic chemical means a substance is a list described in 11,023 of this title, published in 9949, Title 3, Section 329, October 17, 1986, 100 Stat 157. Expedite Public Health. Title 42, Public Health and Welfare, Emergency Planning, Community Right to Know, Subchapter 3, General Provisions, Section 11,050, Authorization Appropriations. Statute authorized appropriated for fiscal years beginning after September 30th, 1986, or such sums as may be necessary to carry out this chapter. Pub 99 to 499, Title 3, Section 330, October 17th, 1986, 100 Stat 758.